Good afternoon. Thank you for joining us for the Provider Standing Revisited webinar. I'm Renee Townsend, here with my partner,
Drew Broadus.
And we're going to talk about the recent orders that were issued on provider standing under the No Fault Act.
Good afternoon, Renee. So the idea we're talking about here is that a healthcare provider, like a hospital, chiropractor, imaging center, who gives services to someone that was injured in a motor vehicle accident, can sue the responsible no-fault carrier directly rather than waiting for that person to bring their own claim. And this idea popped up in a few decisions in the 90s. It's all based on the 1973 statute. But it really took off after a published Court of Appeals decision in 2002, Lakeland NeuroCare versus State Farm. That's 250 MISHAP 35 if you're interested. At that time, providers were sometimes getting assignments from their patients, but after Lakeland NeuroCare, providers were simply relying on the statute itself, specifically 500.3112. So in the decade that followed, provider suits really exploded. We'd see sometimes 3 or more suits from a single claimant from a single accident, sometimes even in different courts. As the carrier started to push back and made arguments like Lakeland NeuroCare really didn't say what the providers were taking it to say, and or that it was wrongly decided, and that the statute didn't provide for these suits. A good example, I lost a published Court of Appeals decision in 2014, Wyoming Chiropractic versus Auto Owners, 308 MISHAP 389, where at that point the Court of Appeals basically said that regardless of whatever issues there may be with the Lakeland NeuroCare opinion, we're going to recognize the cause of action. So after that, the Supreme Court passed on a couple of leave applications, finally grants leave in covenant, and in 2017 holds that myself and many others in the insurance industry were right, and the statute didn't allow for this.
So covenant essentially overruled a long line of Court of Appeals decisions that held the opposite, correct?
It did. And it was odd because the statute never changed, but the Court of Appeals had consistently allowed, at least from Lakeland NeuroCare on, possibly even earlier, that these suits were somewhere in 3112. But when the Supreme Court threw out that reasoning and said that the cause of action does not exist under the statute, they specifically added footnote 40 and said that we're not going to change any rights that these providers might have under assignments. They were only addressing what the statute provided for.
And they decided the statute did not provide providers with standing to bring their own suits, right?
Correct. As it read then, and we'll get to that in a minute. So why does it matter? Well, the legislature amended the statute effective June 11th of this year. So 3112 now specifically says providers can bring these suits directly.
But the only claims that would apply to would be any products, services, accommodations, so any claims incurred or provided after the effective date of the act, which being June 11th, 2019.
Correct. So you have a bunch of cases in the pipeline, cases filed after covenant relying on assignments, cases that didn't rely on assignments at all that were pending at the time of covenant, all sorts of things going on that are in the works in that window. Basically a little more than 2-year window of suits filed before the act takes effect. So the Supreme Court kind of committed itself to hearing these before the statute was amended. They stayed the course, at least keeping them on their docket and having oral arguments on the application. For that reason, you still had a boatload of suits in the works that this was going to decide whether they went on and if so, how.
And as we all saw through practicing in this area or handling claims in this area, the plaintiffs' bar tried a lot of different ways to bring these claims, whether it's through assignments, third-party beneficiary claims, statutory claims, various different things. But ultimately, with this revision of the statute, the only thing that's going to matter is that they do have a statutory claim to bring a suit for those incurred benefits.
Correct. Going forward, it's a very simple issue. But it wasn't before that, and for all the cases that were in the works and for services that the people haven't sued for, you have 1 year from the accident, so you could have people suing for June 10th, 2019 services well into next year, and that's still going to be governed by these decisions. So W.A. Foote was the Court of Appeals published case that held covenant was going to have full retroactive effect to all pending cases. So this was the hot button issue when covenant first came down, and all these providers that didn't have an assignment when they filed suit, too late for them to get an assignment or couldn't track down the patient in some cases, they were left kind of holding the bag. And so the only argument they had to fall back on was, well, covenant's a law change, can only have prospective effect. Court of Appeals disagreed, published a case, may not have gotten the Supreme Court's attention, except for the fact that the Court of Appeals majority said, well, when we look at Supreme Court precedent, there seems to be two different ways of thinking about retroactivity. And so we're going to go down both tracks. We don't think either track leads towards taking away the retroactive application of covenant. In other words, whatever route you go down leads to the same result. Covenant has full retroactive effect because it didn't throw out any Court of Appeal, any Supreme Court precedent, and the statute never changed. Well, that kind of got the Supreme Court's attention because they're saying, well, your case law is inconsistent. So Supreme Court can't have that, regardless of how little interest it may have in the No-Fault Act, which just, by way of background, the Supreme Court's review is always discretionary. And sometimes they evade dealing with these issues for many years. They didn't deal with covenant for many years, and whether the providers had standing under the old act. So, but they did. They granted at least an oral argument on the application, which is kind of a funny procedural way of having a hearing, and then if they don't think the case is that impressive, they can drop the case without passing judgment on the substance.
The other case we're going to talk about is one that everyone's probably familiar with, Shah versus State Farm. Drew, why don't you talk a little bit about that case and its background?
Yeah, it's a closely related issue. What happened here is the provider had filed suit before covenant. Covenant came down. They realized they had a problem, so they went and got an assignment from the injured person and then tried to amend their complaint to say the cause of action was based on the assignment rather than the statute. The State Farm policy in that case had a clause prohibiting assignments. These are fairly common. They're not in every no-fault policy, but they're in a lot, most, I would say. But the Court of Appeals said that clause is not enforceable on public policy grounds, at least for post-loss assignments.
And I think probably, again, anyone handling these types of suits or these types of claims has come across that issue. We were defending a lot of cases initially as the law was evolving and developing, essentially saying, enforce this contract. This is a contractual claim, and our contract prohibits assignments. But the court in Shah said those are against public policy. You can't have that type of clause in your policy.
So the hospital in WA Foote applied for leave, arguing that covenant had to be limited to prospective only application. State Farm, around the same time, applied for leave to the Michigan Supreme Court in Shah, saying that their anti-assignment clause is enforceable. As you can glean from this, they're closely related issues because Shah doesn't really matter if covenant does not apply retroactively. So the court heard those together on the same day earlier this month.
And what did we learn this past week?
Well, we learned that covenant has full retroactive effect, as the Court of Appeals found. The Supreme Court had, I guess you could say, some relatively trivial issues with the Court of Appeals analysis. So for that reason, after the mini oral argument to decide whether to grant leave, the court just went ahead and wrote a one-page order saying affirmed, but one particular part of the Court of Appeals opinion was thrown out, dealing with their attempt to reconcile certain Supreme Court precedents. So because there was no Supreme Court case thrown out by covenant, all of the prior case laws from the Court of Appeals, the threshold question of whether you should limit it to prospective only application was no. So that was the end of the story in the Supreme Court's view.
And then the same thing with Shah. We got a pretty
we got
order.
We got even less in Shah, which is a little bit surprising because Shah has ramifications outside of the no-fault context. But in that case, the court simply denied leave after hearing from the parties. Somewhat surprising after having an oral argument, but it was only a mini oral argument, so it's not unheard of. This leaves the published Court of Appeals opinion in place. So it wasn't affirmed. Technically, someone could still make a challenge against Shah as being wrongly decided in the future, but the odds of the Supreme Court looking at that anytime soon are pretty close to zero because they already had it in front of them in this case and dropped it. There is an interesting side note about Shah, which kind of got lost in the shuffle, is the Court of Appeals opinion also made a finding about how the one-year back rule works with an assignment, and that kind of got lost in the shuffle because it wasn't what the Supreme Court took interest in. But the Court of Appeals Shah panel said that the one-year back is only going to run from the date of the assignment. It doesn't relate back to the complaint, which is going to have ramifications again in these suits that are stuck in the middle. It's not going to matter a whole lot in a couple of years when all the services are post 6/11/19. But that part of the Court of Appeals opinion is still the law, and Supreme Court's not reviewing that either since it dropped the entire case.
So it's still important to look at the date of when the assignment was given, and how you determine how to proceed from there.
Right. For cases that are on the books right now, that assignment date can still be very important.
But in as you said, in a couple of years, as we get away from the June 2019 date, we still have the 1 year back issue at play. Those are issues that are going to kind of fall to the wayside unless something changes.
Right. Unless there's other amendments, and they're just treated like any other no-fault claimant would.
Okay. So the basic holding in both of these cases at this point is what?
Well, providers can't rely on the statute as it was written before 6/11/19. They have no cause of action. They never did. So the covenant holding has full retroactive effect. However, for the providers that had to rely on assignments during that window after covenant before the new statute, we can't challenge those based on our policy language. We have policy language prohibiting assignments. That's not going to be enforced. That's against public policy. The court's basically saying once there's an injury, that's written out. So they're just treated like any other claimant. So this doesn't mean, again, this all relates to standing to file suit. This doesn't mean they file a complaint and get paid. You still adjust them and work them up as you would any other no-fault claim for reasonableness, necessity, relatedness, and all that good stuff. This is all just whether they get to go to the courthouse on their own, and the courts have said they do.
So the slide that's up now provides contact information for Drew and I. If you have any questions about how this is going to affect your cases specifically, or just generally questions about the landscape as we're kind of moving forward, as no fault is evolving, please feel free to contact us. Thanks for joining us.
Thank you.